first things for appellate review, because it makes your job 5,000 times easier. All right, you've gotten the transcript, you've issue spotted, and then you've got to make a decision about, of those issues, which ones do I really want to raise? I've had some where, yeah, that's an issue, but you know what, I'm not going to win on it. And so, you know, you kind of have to make the decision. Do we narrow issues? You know, some defendants want you to raise 10 and 12 issues. I think the law is, you guys who are a lot smarter than I am can remind me, I think the law is, a case called Jones versus Barnes from the Supreme Court of the United States that says basically, when you're the appellate counsel, it's your job, and you have the final determination about what legal issues to raise through the appellate process. So if you get a letter from somebody in prison that says, I want you to raise A, B, C, and D, you can legally say, I've looked at B and C and they're bullshit. So here are the issues I'm going to raise. I think, is that a proper statement of law? Bullshit. Okay. At that point, these are some practical points that I do. You've gotten the transcript, you've spotted your issues. Then you're going to put together an amendment to the motion for new trial. Now, you've already filed, remember, the skeletal general motion for new trial. The principal importance of which is it stops the appellate timeline. It gives you time to do the work you need to do. Well, now you've reviewed the transcript, you've got your issues, and what I do is I prepare usually it's First Amendment to motion for new trial that sets out the separate enumerations and the legal issues I want to raise. And I am as detailed as possible in that amendment. That means argument citations of authority, but also citations to the record and to the transcript. In my opinion, you want to do it as carefully as you can because you've got that time to do that. And also the main advantage of the amendment is it's like a template for your appellate brief that when the notice of docketing comes down from the Court of Appeals to Supreme Court. You'd be surprised. We'll get to that in a second. But that docketing notice can come, and it'll say 20 days, but it took 6 days to get to South Georgia. And so suddenly you've got to put together an appellate brief in 2 weeks and get it out in the mail. If you take your time and put the substance into this First Amendment, when that docketing notice comes, you can say, all right, I'm basically halfway there already. Okay? Does that make sense? Okay. Then get a hearing. Yes, sir.
Let me just interject something, Rob. That's what I do too. One of the other benefits of that thing is that, you know, it may be months between doing the, eventually doing the brief and going through the motion for new trial and hearing and that sort of thing. And the most common beneficiary of that kind of specificity, I've always found is myself, because a month later when you go back and look at that, you know, you might remember generally what the issue was. But it's handy to know that, you know, that you go and look at page 632 to 642, you know, that's where it is. And you know, parallel have a reference to some motion or something like that was found. You know, that's more benefit to you than to anybody else. And it also serves, incidentally, one other thing too. This kind of specificity and frankly making the argument you're going to make at an early stage. About one of the few advantages people have as being the loser of a criminal case and the appellate on appeal is you kind of are firing the first shots. And a lot of times the issues are going to be defined the way you've defined them. And you know, if you define an issue with that kind of specificity and you locate it, you know, in 10 pages in the record, well, it's not necessarily going to keep the other side from wandering off and changing the issue, you know, because of something that happened on page 420, but it reduces the odds of them doing that. The chances are that they're going to look at the record, the same record that you're referring to, and that they're going to look at the same law you're referring to, and that the issues therefore are going to be presented more likely in the terms most favorable to you. Whereas if you're vague about it and you give them a chance to read search through the entire transcript, figure out what you're talking about. And they find something that you'd rather they not have seen on page 420, you know, that affects that particular issue, and suddenly your issue changes.
Right. I think it's to me, it's important at that stage to be as specific as you can. I had a case from the Supreme Court a couple of months back where the issue was the voluntariness of a defendant's statement. And during oral argument, the district attorney was really seriously tap dancing. And he just kind of said, well, you know, under the totality of the circumstances. And Justice Melton looked at him and said, tell me on what page, this, this, and this. And he tap danced some, and then I got up there. Cindy, you were there.
Oh, I was there, all right.
And then I got up there and said, in my rebuttal, and said, look, I didn't drive 4.5 hours to read transcripts to you. But, and because I've been specific, I said on page 67, question, answer, question, answer. And then during the trial record, on this page, question, answer, and sat down. And his conviction was reversed. But, you know, getting that specific early gets you ready for that. In that case, yeah, I was that specific 6 months ago when we did the motion for new trial, okay? The next stage is get a hearing on the motion for new trial. Unless you've got psychotic trial judges, and I'm not saying they don't exist, usually, if you file a skeletal motion for new trial, the case will just sit until you take the active steps to get it moving. That's usual. It might happen, and this happened to me a couple weeks back, you might get some order out of nowhere that says, we're going to have a hearing on this day from the court. That, to me, doesn't happen a lot. Usually it's the defense lawyer saying, I filed my amendment, I'm ready to move forward. It might be that you file with your amendment a Rule nisi. Does everybody know what a Rule nisi is? Okay. That just said you get it, and it gets filed, and then notice goes to everybody, here's the hearing date. Or it might be like we do down where I am, you call the judge's office, talk to the secretary and say, I'm ready on that Al Canty motion for new trial. Okay, I'll set it down on this day. Okay, set down.